Welcome to another episode of the Crypto Exchange, a Troutman Pepper podcast focusing on the world of digital assets. I'm Ethan Ostroff, the host of the podcast and a partner here at Troutman Pepper. Before we jump into today's episode, let me remind you to visit and subscribe to our blogs, Consumer Financial Services LawMonitor.com and TroutmanPepperFinancialServices.com. And don't forget to check out our other podcasts on troutman.com/podcast. Today, I'm joined by my colleague, Addison Morgan, to discuss the CFTC's September 4th enforcement action against Uniswap. Uniswap is the creator of one of the most popular decentralized exchanges in the DeFi industry. Now, this involves the CFTC claiming that through its DEX, Uniswap facilitated retail commodity transactions by enabling consumers to buy and sell ERC20 tokens that track the price movement of Bitcoin and Ether and provide the holder a compound yield, generally about 2x to the upside, if the price of Bitcoin and Ether increases, and to the downside if the price of those tokens decreases. The CFTC characterized these tokens as leverage tokens, and because only designated contract markets, which Uniswap is not, may provide leveraged or margin products. The basis of the CFTC's enforcement action was that Uniswap violated the Commodity Exchange Act. A fascinating enforcement action for a variety of reasons. I'm looking forward, Addison, to talking about this with you today. So before we sort of jump into the theory that the CFTC is pursuing in this enforcement action, just perhaps you might explain to our listeners, how index tokens work from a mechanical standpoint.
Sure, Ethan, and thanks for having me. So the index tokens, and that's just a term we're referring to or utilizing to refer to these particular digital assets, but the tokens at issue in the CFTC's enforcement action are basically ERC20 tokens, like you stated, but what they do is, ironically, they were created to mitigate the risk associated with the traditional margin futures trading that CFTC has regulated. And so how these tokens work is that you have a ERC20 token, which is basically a tokenized representation of an underlying asset, here there being BTC and ETH. And so it's not tokenized in the sense that these holders actually possess BTC and ETH. No, what they are possessing is a token that tracks the price movements of those digital assets. And so like you stated, Ethan, the tokens in this enforcement action were providing basically a 2x compounded yield to their holders. And so as BTC's price increases by 10%, the holders of this token, no matter what their kind of holding is in terms of amount, their holdings will increase by a corresponding 20%. And vice versa to the downside. And so this is a very cool product when you think about it conceptually, because if I were to try to kind of margin trade on my own, what would that require me to do? It will require me to deposit collateral. It will require me to monitor the market to determine whether or not price is approaching, my liquidation risk, where now I might have to add more collateral to my position to prevent that from happening, right? And so this product, just by holding the token itself, that's literally all you have to do is hold the token, you will be provided this yield. And the way that it prevents against liquidation risk is that the underlying kind of smart contract functionality, and this is just computer code now, it automatically rebalances your basically collateral. And so if I were to buy $100 worth of this token, what would happen on the inside, so to speak, is that the smart contract will take that $100, it will take it to a DeFi lending protocol. And I think Index Coop, actually for this product, they utilize Aave. And so Aave is a very popular kind of DeFi lending protocol in the space. It would take that $100, deposit in, you would get $200, right, in exchange, and Aave is just lending to you. And with that $200, the smart contract will buy more Ethereum. And this is all happening just by virtue of holding the token. This smart contract is going and buying more Ethereum. So now, instead of you having an $100 Ethereum position, you now have a $200 Ethereum position because the smart contract took your collateral and basically it created a collateralized debt position. And so that is what's happening here. And it's, distinctly different from what the CFTC usually regulates from a traditional margin standpoint.
Yeah, it's pretty interesting. So I guess the big question is, like whether or not these index tokens are a quote leveraged unquote product, right?
Yeah, agree. And I think, if we have to make a concession, right, I think the concession you can make and still kind of undermine the CFTC's theory is that, yes, these are leveraged tokens in the sense that they provide 2x exposure, right? The mechanism might be different than how margin trading traditionally happens. But yes, ultimately, in exchange for collateral, these holders of this token are receiving double their exposure.
Right. So double their exposure to the price movements of either BTC or ETH, right?
Correct.
So then, I guess another way to sort of think or ask about it or think about it is like, are they leveraged or margined within the meaning of the Commodity Exchange Act, right?
For sure. So that's where I would say no, right? And I think before we get into that, we just provide like a brief overview of the elements of what the retail commodity transaction provision, what they require. So they require a leverage or margin product offered on basically a futures contract basis. And so here, if you think about leverage, how we just explained it earlier and how this smart contract functionality basically does everything on your behalf. If you think about it, Uniswap as the facilitator of these quote unquote retail commodity transactions is neither providing leverage to the public, right? That's happening through Index Coop's own product. And then I would say, secondly, they also are not providing the actual product, right? Their DEX simply acts as a facilitator, but they're not offering products to anyone. Those products are being offered by a third party here, Index Coop.
Interesting. So are there explicit exclusions to this retail commodity transaction provision within the Commodity Exchange Act that are relevant here?
For sure. And so you raise a good point about the actual delivery exception, right? So that is a very important exception to the CFTC's theory and one that they didn't really expound upon in the CFTC's enforcement action against Uniswap. But effectively, the way the CEA, the Commodity Exchange Act as a statute is built upon the theory, you can trade futures contracts, meaning that I can agree to buy a bushel of wheat from Ethan at some price in the future, and I will be exempt from this retail commodity transaction provision if within 28 days of Ethan purchasing that futures contract or me purchasing that futures contract from Ethan actually delivers that bushel of wheat, right? The underlying commodity itself is actually put in Addison's possession. And so here, the actual delivery exception is very fascinating because cryptography and the purchasing and selling of digital assets, and Ethan, this virtually happens instantaneously. And so the idea that notwithstanding whether or not Uniswap is a designated contract market, I think that's not even a dispute. It's not. But all of these transactions being facilitated on their DEX are effectuated through actual delivery, actually providing delivery of the product to the end user, here, the consumers that are navigating the DEX. And so, like I said, in the CFTC's enforcement order, they didn't really speak on, they definitely said that the underlying commodities were not delivered within 28 days, but we'll definitely get into this a little bit later. But if these tokens, the index tokens I'm referring to, are actually commodities because under the CEA, then yes, delivery happened instantaneously. And so they should not be subjected to the CEA on that basis.
Interesting. My recollection is the CFTC, has expounded on what actual delivery and this exception means in practice, right? There's been some interpretive guidance. There's an 11th Circuit decision in the Hunter Wise commodities case, right? So how does that guidance and that decision sort of fit into the theory we see in this enforcement action?
I would say it's contrary to the theory, and I'll just read, so our subscribers are aware of this is an actual quote from a CFTC press release about their March 24th, 2020 final interpreter guidance of the retail commodity transaction provision. And in there, they were primarily interpreting the actual delivery exception, which we are discussing now. And so they state, interpreting actual delivery as meaning, one, a customer securing possession and control over the entire quantity of the commodity, whether it was purchased on margin or using leverage or any other financing arrangement. And two, the ability to use the entire quantity of the commodity freely in commerce, away from any particular execution venue, no later than 28 days from the date of the transaction, and at all times thereafter. Second, the offerer and counterparty seller, including any of their respective affiliates or other persons acting in concert with the offerer or counterparty seller on a similar basis, do not retain any interest in, legal right, or control over any of the commodity purchase on margin, leverage, or other financing arrangement at the expiration of 28 days from the date of the transaction. And so, by the CFTC's own words, right, this enforcement action against Uniswap seems to be invalid and not rooted in what the CFTC's actual interpretation of this exception means, right? Like I just stated, if possession of the entire quantity of the commodity and, basically the facilitator of the transaction here, Uniswap, also cannot have any right in the commodity, then both of those elements are satisfied immediately once a consumer purchases these index tokens or would have purchased these index tokens on Uniswap's DEX. And then secondly, you brought up a very interesting point about the Hunter Wise commodities case, which is another case the CFTC actually relied upon in its enforcement action against Uniswap. And, not Uniswap, but Bitfinex way back, this might have been 2015 or 2016. And there, Bitfinex is being subject to a CFTC enforcement action because, yes, traditional margins trading is actually going on this platform. But in that Hunter Wise commodities case, the 11th Circuit interprets actual delivery as denoting the act of giving real and immediate possession to the buyer or the buyer's agent, which is distinguishable from constructive delivery, which would entail, for example, in the auto finance industry, when you have the title, like if you just have a paper title, that's just constructive delivery in the eyes of the 11th Circuit. Actual delivery would be you having the actual vehicle, right, that's being represented by that paper title. And so, like I said, the commissioners, the other commissioners in the CFTC, they pointed this out, but it seems to me at least that enforcement action against Uniswap clearly contravenes what the CFTC stated back in 2020.
Interesting. So sort of like let's casting forward, right? Trying to read the tea leaves, right? Do we expect the industry to accept this theory and sort of operate going forward with the understanding that, sort of regulation by enforcement should be considered the standard that applies? Or do we think perhaps we're going to see litigation on this issue moving forward? I mean, it's interesting timing, right? Having this discussion now when we just had, crypto.com sue the SEC, right? And then interestingly enough, like crypto.com's affiliated derivatives exchange invoked this mechanism to get the CFTC and the SEC to provide, a joint interpretation about whether or not a particular derivatives product is governed by one, the other, or both, right? So what might we expect coming down the pipeline here?
I mean, that's the crypto.com anecdote is a great segue because that will be the approach moving forward. Maybe not a request for a joint interpretation, but these theories will be contested, right? Because the space is just too novel. And I think many people in the industry don't feel strongly about the technical understandings of either or one of these regulatory agencies. And so, from that standpoint, I think that, yes, the push moving forward will be litigation. And I think the primary reason is just a misunderstanding of cryptography. Like, that actual delivery exception is a very important exception that either Congress, the courts, or, a combination of both will have to come in and really evaluate what actual delivery means within the DEX context. And, there may be variance in other contexts, but in the DEX context, actual delivery is very important because, as you know, Ethan, what we really have here is a vicarious liability theory being imposed upon, DEXs kind of, I wouldn't say haphazardly, but when you look at what the CFTC has previously stated on these points, it seems like this is just a land grab to try to see if we can influence Congress once there is a federal regulatory framework instituted to throw more power our way. It is unfortunate because I think that many people in the industry actually want to be regulated, right? More regulation will bring in more liquidity from traditional financial institutions who want to be in this space, but that just has not happened. And I think it also puts creative thinkers like those at Index Coop who created this product so that retail consumers could basically remove themselves from the litigation risk associated with traditional margin futures, right? Here, you just have to hold the token. That's it. You don't have to manage anything else, just hold the token. And through that, you provided this compounded yield. So I think moving forward, people in the industry, particularly the exchanges, they want clarity, and there's really no clarity through regulation by enforcement, right? They're trying to decide whether or not certain existing business models will be feasible for them in the future. And regulatory enforcement just does not provide an arena for that. So, I know it's a long-winded answer to your question, but these issues are convoluted. And I think to kind of sift through the noise, this is the action that the stakeholders will take.
I think it's important to acknowledge that, there wasn't unanimity amongst the CFTC, right? I mean, there were multiple dissents characterizing the enforcement action as pretextual and without any basis in tested law, right? So even the regulators, as we know, right, whether we're talking about the CFTC or we're talking about the SEC, right, the regulators can't agree.
Yeah.
And so, it's a very difficult situation for stakeholders in this space right now because of just the overwhelming lack of clarity and the sort of, the playing field seemingly changing pretty rapidly and pretty consistently.
Yeah. And I'll just say one more thing on that point. With the kind of overturn of Chevron deference, I think that's just another catalyst for stakeholders in this space to really move forward fervently and not really passively. Like, I think the idea in 2024 that you're just going to interpret whatever you want to interpret the way you want to interpret without that really strong shield that these regulators previously had, I think that will continue to be tested as well. But yes, I agree with your point. We know all about regulation by enforcement, and it'll be interesting to see how this all pans out, with it being an election year.
Yeah, totally agree. I mean, the Luper Wright decision, generally speaking, changes significantly the entire way that these regulators are viewed by industry participants, right? So expect to see a lot more litigation on a variety of different fronts on that. Addison, thanks again for joining me today. Really appreciate it. Your thoughts on this interesting enforcement action. Thanks again to our audience for listening to today's episode. Don't forget to visit our blogs and subscribe so you can get the latest updates. And please make sure to subscribe to this podcast via Apple Podcasts, Google Play, Stitcher, or whatever platform you happen to use. We appreciate, of course, our audience joining us today and look forward to talking to you on our next episode.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.